Good day, everyone. So today I'll be discussing with you the family code, or the title 5, which is the family code. So let's tackle first the chapter 1, the family as an institution. So in article 149, it says here that the family is a foundation of an institution. It is a basic social institution that the public policy cherishes and protects. So every family is being protected by the law. That's why we have this family code. Next, we have the Article 150. The family includes, or the family relations includes, between husband and wife, between parents and children, ascendants and descendants of the parents, and also sister or brother, whether in half or full blood. And then in Article 151, it says here that no suit between members of the same family shall prosper unless it should appear that, or it should appear from the verified complaints or petition that the earnest efforts towards a compromise have been made. So there is no suit between family members unless there is something happened in that between the family. So it's big enough for a family member to file as a case against a family member, but it will be reviewed by the law, or for them to come up with a decision. Next is the chapter 2, which is the family home. Now we're talking about home, or the house of where the family is living, uh, a residence, family residence. In Article 152, it says here that the family home constituted jointly by the husband and the wife or by an unmarried head of a family is a dwelling house where they and their family reside and the land on which it is situated. So, meaning the family home is constituted jointly, or jointly the husband and the wife. The family home considered as a conjugal property of the husband and wife, and another is an unmarried person who is the head of the family, or the one who gives the supports to the family. An unmarried person, or means single, or have a living partner but not married, so he's still an unmarried person. It also being mentioned here about the land where the family is, or the house, the home of the family is being situated. Next is the Article 153. The family home is deemed constituted on a house and lot from the time it is occupied as a family residence. From the time of its constitution, and so long as any of its beneficiaries actually resides therein, the family home continues to be such and exempt from execution, forced sale, or attachment, except as hereinafter provided to the extent of the value allowed by law. Family home is being composed, or known as the house and lot. That time, it is being occupied by a family residence. From the time of its constitution, any beneficiaries resides on family home. Like for example, if other member of the family are living in other places, when there is even only one beneficiary lives on that home, on that family home, then the home is exempted from forced sale, execution, sale, or attachment, except as hereinafter provided and to the extent of the value allowed by law. So, as I said a while ago, the family home is considered as conjugal property. It is not owned by one person. It is owned by two or more person, unless that person is alone in that house, or he built she built that house in her own. Article 154, the beneficiaries of a family home are, so here in Article 154, it talks about the beneficiaries of the family home. First is the husband and wife or unmarried person who is the head of the family. So, again, the beneficiaries of the family home, um, considered or includes husband and wife and an unmarried person who is the head of the family. Next is their parents, ascendants, descendants, brothers and sisters, whether the relationship will be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support. So, this is very understandable that the other beneficiaries includes their parents, the descendants, the sisters and brothers, whether half blood or full blood, legitimate or illegitimate, as long as they are living in that home, in the family home, and who depend upon the legal support of the head of the family. In Article 155, it says here the family home shall be exempt from execution, for sale, or attachment, except. So, the family home shall be exempted from execution, forced sale, or attachment, except. So, there is an exception. First is for non-payment of taxes. If you didn't able to pay the tax you have. Then next is for debts incurred prior to the constitution of the family home. For debts, if you have debts incurred prior to the constitution of the family home. So another thing is for debts secured by mortgages on the premises before or after such constitution. So for debts secured by mortgages, when you say mortgages, it's like you borrow money or you have loan to build this home, family home, before or after such constitution. And lastly, for debts due to laborers, mechanics, architects, builders, material men, and other who have rendered service or furnished material for the construction of the building. This means that, like for example, you weren't able to pay the people who work hard for you to have the family home, for you to build that home. You weren't able to give their salary as what they deserve. Then you will be able to face consequences. In Article 157, it says here the actual value of the family home shall be or shall not exceed at the time of its constitution, the amount of 300,000 pesos in urban areas and the amount of 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. Next, let's tackle Title 6, which is the Paternity and Filiation. Filiation. So paternity talks about father, and then rights of a father, and filiation means the act or process of determining such relationship. Okay, so first we have the chapter 1, legitimate children. Legitimate meaning real, valid, true, fact. Then it's legit. Here in Article 163, the filiation of children may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. In filiation, the filiation of children may be by nature or by adoption. When you adopt, or as long as there is a proof or a letter or an authorization like that, natural filiation may be legitimate or illegitimate. Article 164. Children conceived or born during the marriage of their parents are legitimate. Children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife, provided that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. The instrument shall be recorded in the civil registry together with the birth certificate of the child. This means that they, like for example, if the husband and wife cannot bear children, or there is a problem between the two, so they can have like a donor, sperm donor, or they can have like, they can hire or get some surrogate mother to be inseminated. In that process, they should have an authorization that both parties agreed with that insemination thing. So both parties should sign that they've agreed, and that proof, that authorization should be recorded or attached with a birth certificate and be recorded in the civil registry. Okay? So, next, in Article 165, children conceived and born outside a valid marriage are illegitimate unless otherwise provided in this code. So, children conceived and born outside a valid marriage. Born outside a valid marriage, meaning uh, those children who are born like their parents aren't married yet, or their parents are married to another person, and then they're born, they are legitimate unless otherwise provided by this code. Next is Article 166. Legitimacy of a child may be impugned only in the following grounds. So when we say impugned, it is being opposed. You are contradicting or opposed. That it was, first is that it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of the following. First, the physical incapacity of the husband to have sexual intercourse with his wife. Like for example, like that husband has an illness, or he was being told by that doctor that he can't do that, then that husband has an incapacity of having sexual intercourse with his wife. So that's so impossible for the wife to be pregnant. Another is the fact that the husband and wife were living separately in such a way that sexual intercourse was not possible. So like for example, the husband is an OFW, or the housewife is an OFW, and then the other one is here in the Philippines. So how can they have sexual intercourse when they are separately living? So that's so impossible for the wife to get pregnant. Next, serious illness of the husband, which absolutely prevented sexual intercourse. Serious illness, just like the physical incapacity. When you say serious illness, like for example, this is just my example. The husband has an AIDS, an HIV, or that can be transmitted through sexual intercourse. So the husband was being prevented to have sexual intercourse with his wife. Number two, that it is proved that for biological or other scientific reasons, the child could not have been that of the husband except in the instance provided in the second paragraph of Article 164. So, meaning, for scientific reasons, that child could not have been of that husband. Unless or except, let's refer to the Article 164, which is the insemination, except insemination. So if it is being inseminated, there is a possibility that they can have children without these reasons, or they can have children, or they can have child through insemination. Number three, that in case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. So artificial insemination. So next we have Article 167. The child shall be considered legitimate although the mother may have declared against its legitimacy or have been sentenced as an adulteress. So meaning the child is still considered legitimate even if that the mother doesn't want it, or the mother denied it, because they there is a scientific way of knowing that that child is a legitimate son or daughter of the father or the husband of the wife. Next is Article 168. If the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof of the contrary. So, if the marriage is terminated, first, a child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage. So those children who have been born from the born before 180 days after the solemnization of the subsequent marriage is considered that it is being conceived during the former marriage. It is a child, so meaning it is the child from the former husband. Number two, a child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. Next, Article 170. The action to impugn the legitimacy of the child shall be brought within 1 year from the knowledge of the birth or its recording in the civil register if the husband or, in a proper case of any of his heirs, should reside in the city or municipality where the birth took place or was recorded. So, to impugn the legitimacy of the child, it should be 1 year from the knowledge of its or from the knowledge of birth or its recording in the civil registrar. So if the husband or any of his hers resided in that municipality where that the birth took place or was recorded, should reside in municipality that municipality. If the husband, or in his default, all of his heirs do not reside in the place where birth as defined in the first paragraph, or where it was recorded, the period shall be 2 years if they should reside in the Philippines. 2 years if they reside in the Philippines. And if outside Philippines, then it's 3 years from if the birth of the child has been concealed from or was unknown to the husband or hers, the period shall be counted from the discovery of the knowledge of the birth of the child or of the fact of registration of said birth, with whichever is earlier. So, like for example, if the wife gave birth without the knowledge of the husband, then the husband uh, can start count from the discovery of or the knowledge of the birth of the child or the registration of the said birth, whichever is earlier. Next is in Article 171, the heirs of the husband may impugn the filiation of the child within the period prescribed in the preceding article only the following cases. First is if the husband should die before the expiration of the period fixed for bringing his action. Next, if he should die after the filing of the complaint without having desisted therefrom. Or the third one, if the child was born after the death of the husband. So they can oppose the filiation of the child in these cases. Next is Chapter 2, Proof of Filiation. In Article 172, it says here that filiation of legitimate children is established by any of the following. First, the record of birth in the civil registrar or final judgment. So, the filiation of legitimate children established by any of the following. First is the record of the birth of appealing in the civil registrar or the final judgment of the law. Next is an admission of legitimate filiation, a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be approved by, first, the open and continuous possession of the status of a legitimate child, or any other means allowed by the rules of court and special laws. So, any other means allowed by rules of court and any other special laws. Next is Article 174. Legitimate children shall have the rights. So these are the rights of the legitimate children. First, to bear the surnames of the father and the mother in conformity with the provisions of the Civil Code on surnames. So, legitimate child, they have the rights to bear the surnames of the mother or the father. Next is to receive support from their parents, their ascendants, and in proper cases, their brothers and sisters in conformity with the provision of this code on support. So, they also have the rights to seek supports from their families, their parents, their ascendants and descendants. Third and last is to be entitled to the legitimate and other successional rights granted to them by the Civil Code. Next is chapter 3, legitimate children. Earlier we talked about legitimate children, and now we talk about illegitimate children. Article 175 says that illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. So now we are going to proceed Title 7, which is the adoption. In Article 183, a person of age and in possession of full civil capacity and legal rights may adopt, provided he is in a position to support and care for his children, legitimate or illegitimate, in keeping with the means of the family. You are capable to adopt if you have uh, if you have the position to care, to support the children you are adopting, illegitimate or legitimate. Only minors may be adopted, except in the cases when the adoption of a person of majority age is allowed in this title. In Article 184, the following persons may not adopt. First, the guardian with respect to the ward prior to the approval of the final accounts rendered upon the termination of their guardianship relation. The guardianship relation being terminated. So, that person may not adopt. Second, any person who has been convicted of a crime involving moral turpitude. Any persons involving in a crime may not adopt. An alien, except a former Filipino citizen who seeks to adopt to a relative by consanguinity. A former Filipino citizen can adopt. Letter B, the one who seeks to adopt the legitimate child of his or her Filipino spouse. Those who get married, those foreigners or an alien who get married to a Filipino can adopt their legitimate child. C, the one who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse, a relative by consanguinity of the latter. Next is the Article 187. The following may not be adopted. So these are the persons that may not be adopted for some reasons. First, a person of legal age. So it's 18. Unless he or she is a child by nature of the adopter or his or her spouse or prior to the adoption. Said person had been consistently considered and treated by the adopter as his or her own child during minority. So, a person who is a person of legal age may not be adopted unless he or she is being treated by the adopter as a family or as a child since minority. Next is an alien with whose government the Republic of the Philippines has no diplomatic relations. Third one is a person who has already been adopted unless such adoption has been previously revoked or rescinded. A person who had been already adopted by someone unless that adoption before was being revoked or rescinded. The last one is the Article 188. The written consent of the following to the adoption shall be necessary. This is necessary in the adoption process. The written consent, meaning that you allow that person to be adopted or you you are adopting that child. First, the person to be adopted if 10 years of age or over. So, the person to be adopted if 10 years of age or over needs written consent. The parents by nature of the child, the legal guardian, or the proper government instrumentality. Third one, the legitimate and adopted children, 10 years of age or over of the adopting parent or parents. Fourth one, the illegitimate children, 10 years of age or over of the adopting parent if living with the said parent and the latter spouse if any. And the last one, the spouse if any of the person adopting or to be adopted. These five needs written consent during the adoption. That's all for my report, and thank you.